By the time the county deputies cut through the chain securing the narrow gravel path to my property, several HOA members were already shouting about public right-of-way and something about neighborhood wellness. Their voices dropped to a whisper when I handed over a thick file containing notarized letters, topographic surveys, and a formal damages estimate totaling $3 million for trespassing, harassment, and illegal blockade. One deputy scanned the folder, then turned to the HOA president and said, "You might want to find a seat. This is going to be a long day. My name is Jonathan Reed, and I bought my cabin near Ridgeview Lake for solitude and space. The lake itself, fully titled to me, complete with water rights stretching back nearly a century." But Clarissa Minton, the HOA president of Ridgeview Hills, had other plans. She believed the lake would be better off as a community park. Translation: she wanted to tear down my dock, pave over part of my shoreline, and invite families I'd never met to picnic on my property. Clarissa had a voice that could turn sunshine sour, honey-coated with passive aggression. 3 months after I moved in, she arrived unannounced on a Saturday morning. Clipboard in hand, smile fake as a plastic plant. "Mr. Reed," she began, "we need to have a conversation about your unwillingness to share our community's natural resources." I asked her what part of private deed she didn't understand. She huffed and said, "This lake affects everyone's property value. It's antisocial to claim it all for yourself." I shut the door on her mid-rant. The next few weeks brought an avalanche of letters. At first, polite, offering to buy the lake rights for ceremonial sums, in the spirit of neighborly cooperation. One read, "To promote unity, we'd appreciate your thoughtful transfer of water rights to Ridgeview HOA for $1. I didn't respond, so the letters soured. Then came the threats, fines for unmanaged shoreline, false claims about non-native fish species, even a phony letter alleging my boat registration had been suspended by the state. It was harassment, dressed up in fake legality. The fines escalated: $50 for dock disrepair, $300 for unauthorized aquatic changes. Clarissa delivered the notices herself, always flanked by 2 or more HOA goons in matching polos. "We just want to help you stay within compliance, Jonathan," she'd say with a tone that barely concealed menace. When I still didn't cave, she pulled something outrageous. One Monday morning, I woke up to a metal security gate across the only road to my land. Not just a chain, but concrete posts and reinforced steel. A laminated notice read, "Access restricted. Only compliant residents allowed entry." I had to call my boss and explain I was barricaded inside my own property. He thought I was joking, until I texted him the pictures. I marched to the gate. Clarissa stood smugly with her board in tow, all wearing Ridgeview Hills logos like they were a private army. She smiled and said, "Didn't you get the notice? You're not a compliant member. Once you agree to the community's shared lake initiative, access will be restored." I asked if she realized she was illegally trapping me. "Oh, no one's trapping you," she purred. "You're welcome to leave, once your paperwork's in order." I called my attorney, Malcolm King. He barely let me finish before saying, "Jonathan, congratulations. They just stepped into a minefield." Malcolm was giddy. He explained that under state law, restricting access to private property like this qualified as false imprisonment, interference with egress, and several civil violations. He grinned, "Let's document every inch of this mess." So I did. Drone footage, time-stamped videos, photographs of the padlock and signs. I even hired a local investigator who captured Clarissa at a cafe bragging about her plan to turn the Reed property into Ridgeview's recreational jewel. She told a friend, "He'll fold soon. I'm already designing the boat ramp." With every recorded comment, the damages climbed. Malcolm calculated daily penalties per board member. He filed complaints with civil court and the sheriff's office, sending cease and desist letters to every HOA officer's home and workplace. We even discovered Clarissa had sent HOA messages from her corporate job email at a financial firm. Malcolm copied her company's HR department in the complaint, warning that they could be liable. Once the sheriff reviewed our case, things moved fast. Officers arrived, bolt cutters in hand, and handed each board member their own copy of the lawsuit. The lead deputy, built like a linebacker, turned to Clarissa and said, "Ma'am, restricting property access without authority isn't just wrong, it's criminal. You're towing the line of kidnapping." Clarissa turned pale, arguing about community wellness and fair access. The deputy cut her off. "I don't care if you think there's buried treasure in that lake. You can't trap someone on their own land." She was forced to hand over the gate key. It was dismantled that afternoon. But it was only the beginning. The sheriff's office launched a formal investigation. The district attorney took interest due to what they called a coordinated scheme of intimidation. Our civil suit snowballed. Clarissa's own emails revealed intent. The gate receipts proved forethought. We subpoenaed Ridgeview WA meeting notes. There it was in black and white, weeks of discussion on how to force lake access. That night's WA emergency meeting spiraled into chaos. Homeowners were furious to learn their increased dues were secretly used to defend Clarissa's actions. One man yelled, "You said this was for road maintenance, not your fantasy park project." Another shouted, "You just dragged us all into a lawsuit." Clarissa tried to restore order while her board mates scooted their chairs away from her. Their lawyer, a jittery guy named Neil Burns, stammered about implied easement rights in the preliminary hearing. Judge Marla Jefferson raised an eyebrow and asked, "Did you even read your own WA charter?" She pulled out the bylaws and read, "Lake ownership and access remain the private right of individual title holders." Then she added, "This isn't just negligence. It's willful and idiotic." During discovery, more dirt surfaced. Clarissa had paid for the gate installation without a full board vote, an $8,000 decision made solo. She'd also funneled over $40,000 from special homeowner assessments into her unapproved lake project. One elderly resident testified she'd been told it was for storm drainage repairs. "I feel tricked," she said, trembling. 30 days later, Ridgeview Hills WA lost in court. The judgment, $3.04 million. Breakdown, $500 per day per board member, attorney fees, and punitive damages. Judge Jefferson declared, "This court finds the defendants conduct malicious, premeditated, and a textbook example of WA abuse." The headline in the county paper read, "WA President Drowns Community in Debt Over Lake Power Grab." Neighbors started protesting outside Clarissa's home. Signs read, "Give us back our dues," and, "You ruined this neighborhood." Her employer let her go after clients complained. "We can't trust someone accused of fraud with our money," one wrote in a public review. Before the WA could collect more fees, the state attorney general stepped in. The organization was officially dissolved, and an investigation into fraud and misuse of funds began. The criminal trial came quickly. Clarissa was convicted of false imprisonment, embezzlement, and criminal trespass. Her sentence, 18 months suspended to 5 years probation, 3,000 hours of community service helping elderly WA victims, and a permanent ban from ever holding a neighborhood leadership role again. When the sentence was announced, she collapsed, sobbing, "I was trying to build a legacy." Judge Jefferson didn't flinch. "No," she said coldly. "You were trying to steal. Now you've paid the price."